Mr. Chair, I think the members for, I think some well-made points at short notice. Let's all accept having this bill under urgency in the House. I mean, I think we can all agree it's much better if these bills can optimally go through select committee process, have serious consideration over weeks, if not months. But we do know here as well, I think, that this does need to be urgent. We cannot have a situation where people, having thought the speed limits in certain areas were always such, now think could lodge appeals and the like on the basis that it was okay to be driving that fast, to be going dangerously fast in many cases on those roads. And of course, prospectively, we need to ensure safety as well with the utmost urgency. And I think in this case, the confidence and the safety points trump those other points. Can I say I also go some way with Dennis O'Rourke on his point that, look, the precedent here, we shouldn't be validating mistakes. Leave them to it. Of course, we could, in a sense, in theory, do that were it in some area, I think, where safety wasn't the case. But I think in this situation, given the seriousness of what we are dealing with, speed limits, our roads, where, look, 9.5, 10 out of 10 people travel, we do need to act in this way. Can I just say briefly, I hope I've got effectively all of the points made by Mrs Parker and O'Rourke. Clauses 8 and 9, Mr Parker, and I think to some extent Dennis O'Rourke's analysis is absolutely correct. So I accept what they are saying there. I think on the point about the remove any doubt and the SOP that's been put forward by David Parker, I understand the point they make. I think in discussion with officials, we maintain sticking with the words we have because we do think they are a more accurate summation of what the position is, which is that we are not 100% certain that the bylaw is invalid. That is what this is in relation to. That's correct. The purpose clause. In our legal arguments, we believe that we're probably right, but we are, in a sense, being belts and braces, and that is an argument we want to be as accurate as we can be for the courts of New Zealand, effectively, who interpret these laws on these points. I mean, it's a small point in a sense. I mean, part of me says, well, maybe we could do what the Honourable David Parker is saying here, but I think that's the position and the time we've got that I come to. I think if we go through clauses 11 and 12, there were comments made about those. Clause 11, as I understand it, my reading of it, is in broad terms about putting this into the land transport law where it belongs and having it as a land transport issue and not some wider local government one. Clause 12 broadly preserves consultation provisions on bylaws, which I think we all agree is the right thing to do. I don't think I accept some of what Dennis O'Rourke and to some extent David Parker are saying on clause 6. Now, if I just quickly turn to that provision, I am trying to do justice points they've made because, as I say, I am conscious this is a bill that won't have select committee consideration. Well, I'm about to go through it. I don't accept the unduly broad point of Dennis O'Rourke in the sense that I think that there are the provisos, the qualifying provisions of A, B and C of one. I think there's other clauses as well. We've talked already actually about what is it, the purpose of clause, the saving for certain legal proceedings and what that is about. I think David Parker makes some very interesting points on clause 1 6.1 have been lawfully made and to be and always have been valid despite. And it is possible, Mr. Chair, it is possible that he is right. But I'm not going to go with him, and I want to explain why. I think in this, I think that in this bill we do need. Well, no, and then we might be back here, Mr. Parker, and that is not what I want. I think we can accept to some extent some of this bill could be with another month more felicitously worded. We could have, you know, Jane Austen could have been proud of it. But we have gone through it very carefully. We do think it does the job and provides the certainty and the safety that is required. We don't think it has unintended consequences. And I think in terms of those phrases, and actually section 6.2, which I think the members raised, we are, I think necessarily taking a belts and braces approach to this, because I think we can all agree we don't want to be back here. We do want to fix a position that has been created, where bylaws have been created, they haven't been reviewed, and on that basis revoked. We do want to make sure the public of New Zealand today have absolute certainty and are absolutely safe that the speed limits in the towns and cities that they live in are what they say on the signs. And so, Mr. Speaker, I accept the good contributions made and the spirit that have been made, which is good faith, and I think with some learning. But I think we want to take a belts and braces approach that passes this law and keeps New Zealand safe.